Loving v. Virginia, 388 U.S. 1, was a landmark civil rights decision of the United States Supreme Court which invalidated laws prohibiting interracial marriage. The case was brought by Mildred Loving, a black woman, and Richard Loving, a white man, who had been sentenced to a year in prison in Virginia for marrying each other. Their marriage violated the state's anti-miscegenation statute, the Racial Integrity Act of 1924, which prohibited marriage between people classified as white, and people classified as colored. The Supreme Court's unanimous decision held this prohibition was unconstitutional, overturning Pace v. Alabama and ending all race-based legal restrictions on marriage in the United States. The decision was followed by an increase in interracial marriages in the U.S., and is remembered annually on Loving Day, June 12. It has been the subject of 2 movies as well as songs. Beginning in 2013, it was cited as precedent in U.S. federal court decisions holding restrictions on same-sex marriage in the United States unconstitutional. Background: anti-miscegenation laws in the United States had been in place in certain states since before the United States declared independence. At the time that the decision was handed down, 17 states, all southern states, had such laws. Plaintiffs. The plaintiffs in the case were Mildred Dolores Loving, now copyrightee Jetta, a woman of African American and Rappahannock Native American descent, and Richard Perry Loving, a white man. The couple had 3 children, Donald, Peggy, and Sidney. Richard Loving died aged 41 in 1975, when a drunk driver struck his car in Caroline County, Virginia. Mildred Loving lost her right eye in the same accident. She died of pneumonia on May 2, 2008, in Milford, Virginia, aged 68. Criminal proceedings: at the age of 18, Mildred became pregnant, and in June 1958 the couple traveled to Washington, D.C. to marry, thereby evading Virginia's Racial Integrity Act of 1924, which made interracial marriage a crime. They returned to the small town of Central Point, Virginia. Based on an anonymous tip, local police raided their home at night, hoping to find them having sex, which was also a crime according to Virginia law. When the officers found the Lovings sleeping in their bed, Mildred pointed out their marriage certificate on the bedroom wall. That certificate became the evidence for the criminal charge of cohabiting as man and wife, against the peace and dignity of the Commonwealth that was brought against them. The Lovings were charged under Section 20-58 of the Virginia Code, which prohibited interracial couples from being married out of state and then returning to Virginia, and Section 20-59, which classified miscegenation as a felony, punishable by a prison sentence of between 1 and 5 years. The trial judge in the case, Leon M. Bazile, echoing Johann Friedrich Blumenbach's 18th-century interpretation of race, wrote, on January 6, 1959, the Lovings pled guilty and were sentenced to 1 year in prison, with the sentence suspended for 25 years on condition that the couple leave the state of Virginia. They did so, moving to the District of Columbia. Appellate proceedings: in 1964, frustrated by their inability to travel together to visit their families in Virginia and social isolation and financial difficulties in Washington, Mildred Loving wrote in protest to Attorney General Robert F. Kennedy. Kennedy referred her to the American Civil Liberties Union. The ACLU filed a motion on behalf of the Lovings in the Virginia trial court to vacate the judgment and set aside the sentence on the grounds that the violated statutes ran counter to the 14th Amendment. This set in motion a series of lawsuits which ultimately reached the Supreme Court. On October 28, 1964, after the Lovings' motion still had not been decided, they brought a class action suit in the U.S. District Court for the Eastern District of Virginia. On January 22, 1965, the 3-judge District Court decided to allow the Lovings to present their constitutional claims to the Virginia Supreme Court of Appeals. Virginia Supreme Court Justice Harry L. Carrico wrote an opinion for the court upholding the constitutionality of the anti-miscegenation statutes and, after modifying the sentence, affirmed the criminal convictions. Ignoring United States Supreme Court precedent, Carrico cited as authority the Virginia Supreme Court's own decision in Name v. Name, also arguing that the case at hand was not a violation of the 14th Amendment Equal Protection Clause because both the white and the non-white spouse were punished equally for the crime of miscegenation, an argument similar to that made by the United States Supreme Court in 1883 in Pace v. Alabama. The Lovings, supported by the ACLU, appealed the decision to the United States Supreme Court. They did not attend the oral arguments in Washington, but their lawyer, Bernard S. Cohen, conveyed the message he had been given by Richard Loving to the court. Mr. Cohen, tell the court I love my wife, and it is just unfair that I can't live with her in Virginia. Precedents. Before Loving v. Virginia, there had been several cases on the subject of interracial relations. In Pace v. Alabama, the Supreme Court ruled that the conviction of an Alabama couple for interracial sex, affirmed on appeal by the Alabama Supreme Court, did not violate the 14th Amendment. Interracial marital sex was deemed a felony, whereas extramarital sex was only a misdemeanor. On appeal, the United States Supreme Court ruled that the criminalization of interracial sex was not a violation of the Equal Protection Clause because whites and non-whites were punished in equal measure for the offense of engaging in interracial sex. The court did not need to affirm the constitutionality of the ban on interracial marriage that was also part of Alabama's anti-miscegenation law, since the plaintiff, Mr. Pace, had chosen not to appeal that section of the law. After Pace v. Alabama, the constitutionality of anti-miscegenation laws banning marriage and sex between whites and non-whites remained unchallenged until the 1920s. In Kirby v. Kirby, Mr. Kirby asked the state of Arizona for an annulment of his marriage. He charged that his marriage was invalid because his wife was of Negro descent, thus violating the state's anti-miscegenation law. The Arizona Supreme Court judged Mrs. Kirby's race by observing her physical characteristics and determined that she was of mixed race, therefore granting Mr. Kirby's annulment. In the Monks case, the Superior Court of San Diego County in 1939 decided to invalidate the marriage of Marie Antoinette and Alan Monks because she was deemed to have 1/8 Negro blood. The court case involved a legal challenge over the conflicting wills that had been left by the late Alan Monks. An old one in favor of a friend named Ida Lee, and a newer one in favor of his wife. Lee's lawyers charged that the marriage of the Monkses, which had taken place in Arizona, was invalid under Arizona state law because Marie Antoinette was a Negro, and Alan had been white. Despite conflicting testimony by various expert witnesses, the judge defined Mrs. Monk's race by relying on the anatomical expertise of a surgeon. The judge ignored the arguments of an anthropologist and a biologist that it was impossible to tell a person's race from physical characteristics. Monks then challenged the Arizona anti-miscegenation law itself, taking her case to the California Court of Appeals, 4th District. Monks' lawyers pointed out that the anti-miscegenation law effectively prohibited Monks as a mixed-race person from marrying anyone. As such, she is prohibited from marrying a Negro or any descendant of a Negro, a Mongolian or an Indian, a Malay or a Hindu, or any descendants of any of them. Likewise, as a descendant of a Negro she is prohibited from marrying a Caucasian or a descendant of a Caucasian. The Arizona anti-miscegenation statute thus prohibited Monks from contracting a valid marriage in Arizona, and was therefore an unconstitutional constraint on her liberty. However, the court dismissed this argument as inapplicable, because the case presented involved not two mixed-race spouses but a mixed race and a white spouse. Under the facts presented, the appellant does not have the benefit of assailing the validity of the statute. Dismissing Monk's appeal in 1942, the United States Supreme Court refused to reopen the issue. The turning point came with Perez v. Sharp, also known as Perez v. Lippold. In Perez, the Supreme Court of California recognized that bans on interracial marriage violated the 14th Amendment of the federal Constitution. Decision: the U.S. Supreme Court overturned the Loving's convictions in a unanimous decision, dismissing the Commonwealth of Virginia's argument that a law forbidding both white and black persons from marrying persons of another race and providing identical penalties to white and black violators could not be construed as racially discriminatory. the court ruled that Virginia's anti-miscegenation statute violated both the Due Process Clause and the Equal Protection Clause of the 14th Amendment. Chief Justice Earl Warren's opinion for the unanimous court held that, the court concluded that anti-miscegenation laws were racist and had been enacted to perpetuate white supremacy. Associate Justice Potter Stewart filed a brief concurring opinion. He reiterated his opinion from McLaughlin v. Florida that it is simply not possible for a state law to be valid under our Constitution which makes the criminality of an act depend upon the race of the actor. Implications of the decision: for interracial marriage, despite the Supreme Court's decision, anti-miscegenation laws remained on the books in several states, although the decision had made them unenforceable. In 2000, Alabama became the last state to adapt its laws to the Supreme Court's decision, by removing a provision prohibiting mixed-race marriage from its state constitution through a ballot initiative. 60% of voters voted for the removal of the anti-miscegenation rule, and 40% against. After Loving v. Virginia, the number of interracial marriages continued to increase across the United States and in the South. In Georgia, for instance, the number of interracial marriages increased from 21 in 1967 to 115 in 1970. At the national level, 0.4% of marriages were interracial in 1960, and 2.0% in 1980. In the 2010 census, 10% of opposite-sex married couples are partners of a different race, 25 times more than in 1960. For same-sex marriage, Loving v. Virginia is discussed in the context of the public debate about same-sex marriage in the United States. In Hernandez v. Robles, the majority opinion of the New York Court of Appeals that state's highest court declined to rely on the Loving case when deciding whether a right to same-sex marriage existed, holding that the historical background of Loving is different from the history underlying this case. In the 2010 Federal District Court decision in Perry v. Schwarzenegger which overturned California's Proposition 8 Judge Vaughn R. Walker cited Loving v. Virginia to conclude that the constitutional right to marry protects an individual's choice of marital partner regardless of gender. On more narrow grounds, the Ninth Circuit Court of Appeals affirmed. In June 2007, on the 40th anniversary of the issuance of the Supreme Court's decision in Loving, commenting on the comparison between interracial marriage and same-sex marriage, Mildred Loving issued a statement in relation to Loving v. Virginia and its mention in the ongoing court case Hollingsworth v. Perry. In December 2013, the United States District Court for the District of Utah repeatedly cited Loving in its decision Kitchen v. Herbert, which held unconstitutional Utah's ban on same-sex marriage. In February 2014, Judge Orenda L. Wright Allen, writing for the United States District Court for the Eastern District of Virginia in Bostick v. Rainey, not only cited Loving, but also prefaced her opinion with Mildred Loving's above-mentioned statement of 2007. In May 2014, Pulaski County Circuit Judge Chris Piazza likewise cited Loving as precedent when holding Arkansas's ban on same-sex marriage unconstitutional in Wright v. Arkansas. In popular culture, in the United States, June 12, the date of the decision, has become known as Loving Day, an annual unofficial celebration of interracial marriages. The story of the Lovings became the basis of two films. Mr. and Mrs. Loving was written and directed by Richard Friedenberg, and starred Lela Rocken, Timothy Hutton, and Ruby Dee. According to Mildred Loving, not much of it was very true. The only part of it right was I had 3 children. The second film, The Loving Story, premiered on HBO in February 2012 and won a Peabody Award that year. In music, the case has been the subject of Drew Brody's 2007 folk music ballad of Mildred Loving, and Nancy Griffith's 2009 song The Loving Kind. Griffith wrote the song after reading Mildred Loving's obituary in the New York Times, and received the ACLU's Bill of Rights Award for it. References. Further reading. External links. Text of Loving v. Virginia, 388 US 1 is available from, a Findler UMKCA, ABC News: A groundbreaking interracial marriage. Loving v. Virginia at 40. Interview with Mildred Loving and video of original 1967 broadcast. June 14, 2007. Resources at Oyers including complete audio of the oral arguments. Loving Day, June 12. Commemorating legalization of interracial couples, The Loving Story. Nancy Bursky's documentary film, Loving Decision, 40 Years of Legal Interracial Unions. National Public Radio, All Things Considered, June 11, 2007. The 40th anniversary of Loving v. Virginia, The Legal Legacy of the Case That Ended Legal Prohibitions on Interracial Marriage. FindLaw commentary by Joanna Grossman. 40 Years of Interracial Marriage, Mildred Loving reflects on breaking the color barrier. AP article in International Herald Tribune, Mr. and Mrs. Loving at the Internet Movie Database, New York Times article upon the death of Mildred Loving, Encyclopedia Virginia. Loving v. Virginia, Mildred Loving's obituary from The Economist, Chin, Gabriel and Rishi Karthikeyan, Asian Law Journal Volume 9. Preserving Racial Identity, Population Patterns and the Application of Anti-Miscegenation Statutes to Asian Americans, 1910 to 1950.